Case 1. Toshikazu Sugaya. On December 7, 1990, in the city of Ashikaga in Tochigi Prefecture, Japan, a 4-year-old girl named Mami Matsuda did not come home. She had been playing near her house. It was the kind of late afternoon that families in quiet Japanese cities stopped worrying about years ago. A familiar street, familiar neighbors, a short walk. Mami was found the next morning. She had been strangled. She was 4 years old. The investigation moved quickly, the way investigations do when the victim is a child and the community is watching. Police focused on a man named Toshikazu Sugaya, a bus driver for a local kindergarten, someone who interacted with children regularly, someone who knew the area, someone whose alibi was imprecise in ways that investigations tend to find meaningful. He was brought in for questioning. He denied everything, but the questioning did not stop. 12 hours a day, no lawyer, the same questions orbiting the same accusation. The walls of a police interrogation room do something to a person that is difficult to describe unless you have experienced it. You begin to lose track of time. You begin to lose the firm outline of your own certainty. The investigators told Sugaya they knew he had done it. They told him the evidence confirmed it. They had, in fact, conducted a rudimentary DNA test on material from the crime scene. The technology was crude, the analysis was inadequate, but in that room it was presented as unambiguous. In 1991, Sugaya confessed. He was convicted of the murder of Mami Matsuda and sentenced to life in prison. For the next 17 years, he would tell anyone who would listen that he had not done it. He said it to guards, he said it to lawyers, he said it in appeal after appeal that went nowhere, that were reviewed by courts operating within the same institutional logic that had convicted him in the first place. The system does not respond well to the idea that it was wrong. The system's response, more often than not, is to wait. In 2009, advances in DNA technology prompted a review of the biological evidence. When the new analysis was completed, the results were unambiguous, not in the way the original investigators had claimed, but actually genuinely unambiguous. Toshikazu Sugaya's DNA did not match the material from the crime scene. It had never matched. The original forensic work had been so primitive, so methodologically flawed, that investigators had convinced themselves of a connection that did not exist, and then used interrogation to fill in the rest. Sugaya walked out of Ashikaga prison on June 4, 2009. He was 62 years old. He had entered at 45. He had missed his mother's death. He had missed nearly 2 decades of the world continuing without him. The Japanese government issued a formal apology and compensatory payment, which is what governments do when they have done something to a person that cannot be undone. The man who actually killed Mami Matsuda, a 4-year-old girl who did not come home from playing outside one December afternoon, was never identified, never charged, never spent a single day in custody. He has been free for more than 30 years while someone else served his sentence. Case 2. Iwo Hakamada. On June 30, 1966, in Shizuoka Prefecture, 4 members of a family were found dead in their home. The father, the mother, and 2 of their children had been stabbed. The house had been set on fire. It was methodical, and it was brutal, and it required an answer. Police arrested Iwo Hakamada. He was 30 years old, a former professional boxer, and he worked at the soybean processing factory owned by the murdered family. The employment connection was treated as proximity. Proximity was treated as evidence. Hakamada was interrogated for 20 days, no lawyer, 12 hours a day. Investigators later testified, under oath, in open court, that they had used physical force during questioning. They said this on the record. The record did not result in the prosecution being abandoned. After 20 days, Hakamada signed a confession. He recanted it almost immediately. He said, clearly and repeatedly, that he had confessed because of what was being done to him, not because the confession was true. It did not matter. He was convicted in 1968 and sentenced to death. Then he waited 46 years, not 46 months, 46 years on death row. He became, by any historical accounting, the longest-serving death row inmate in recorded human history. In Japan, the particular cruelty of the death penalty system is that inmates are not told of their execution date in advance. They are told on the morning it is going to happen. They wake up on what might be any day, and sometimes it is the last day, and they have had no time to prepare, no time to say goodbye, no time to do anything except walk. Hakamada woke up to that possibility every morning for 46 years. Under that weight, his mind eventually bent. He stopped being certain he was Iwao Hakamada. He constructed an interior world, an alternate reality, that allowed him to survive in a place designed to break him. By the time he was released, many who encountered him said they were not sure how much of him remained. Hakamada was 78 years old when he walked out of the facility where he had spent nearly half a century. His retrial concluded in September 2024. He was acquitted. He was 88 years old. The real killer of those 4 people in Shizuoka, a family, a father and mother and 2 children, has never been identified. They have been dead for nearly 60 years. No one has ever been held accountable for their murders. Case 3. Govinda Prasad Manali. On May 14, 1997, in an apartment in Tokyo's Ibisu neighborhood, a 39-year-old Japanese woman named Yasuko Watanabe was found dead. She had been strangled. The apartment was in one of Tokyo's more prosperous districts, Ibisu, a neighborhood of tree-lined streets and well-maintained buildings, the kind of place where violent death felt, to the people who lived there, like something that happens somewhere else. Police canvassed the building, interviewed residents, and focused on a man who had been seen in the area, a Nepalese national named Govinda Prasad Mainali, who worked as a restaurant cook and lived nearby. He was 32 years old. He had come to Japan the way many migrants come to wealthy countries, for work, for opportunity, for the particular kind of future that requires leaving the place you are from. He had built a quiet life. He knew the neighborhood. He was visible in the way that people who work long hours in service jobs are visible, present, useful, unremarkable, until suddenly they are not. That visibility became the foundation of the case against him. There was no physical evidence directly linking him to the crime. No fingerprints, no fiber, no trace material placing him inside the apartment on the night Yasuko Watanabe died. The case against him was built almost entirely on circumstantial detail, his presence in the neighborhood, the accounts of witnesses who placed him near the building, the absence of an alibi that satisfied investigators. When police looked at Govinda Prasad Manali, they saw proximity. They decided proximity was enough. Mainali said he had nothing to do with it. He said this clearly, and he said it repeatedly, but he said it in a language that was not his own, navigating a legal system whose procedures and assumptions were entirely foreign to him, surrounded by investigators who had already decided that he was the answer they were looking for. In Japan, the interrogation system is designed around the presumption that the person in the room is guilty, that the task is not to determine guilt, but to confirm it, to extract the statement that will allow the process to move forward. For a Japanese national, that environment is disorienting and coercive. For a foreign national, without full command of the language, without any framework for understanding what his rights were or whether he had any, it was something worse. There was, in the evidence from the crime scene, biological material, DNA, The technology to analyze it meaningfully existed, but investigators did not submit it for that kind of analysis. He served that sentence in full, not a reduced term, not an early release, but the complete weight of a life sentence in a country that was not his, among people whose language he spoke imperfectly, separated from his family in Nepal by a distance that was not only geographical. He was deported in 2009. He was not resuming something. He was beginning something new, later than he should have had to, in the wreckage of what had been taken. The man whose DNA was actually present at the scene of Yasuko Watanabe's murder has never been found. No arrest has ever been made. No charge has ever been filed. She was 39 years old when she was killed, a woman in the middle of her life, in her own home, in a neighborhood where violent death was not supposed to happen. She has been dead for nearly 30 years. The person responsible has faced no consequence, has answered no question, has sat across from no investigator in any room. The case is, in the formal language of the justice system, unsolved. In the plain language of what actually happened, it is something else, a murder that was committed, attributed to the wrong man, and then quietly set aside. The file closed, the investigation ended, the real perpetrator left to whatever life he has lived since May of 1997. Case 4. The Saga Prefecture Murders. Between 1986 and 1988, in Saga Prefecture in southern Japan, 7 people were killed. The murders were spread across multiple locations over an extended period, linked by investigators into a single investigation. Police arrested a suspect and brought him in for questioning. What happened inside that interrogation room is documented in court testimony. The man was subjected to what investigators and courts would eventually describe as violent interrogation. He was not questioned, he was broken. Under sustained physical and psychological pressure, over days that accumulated into something the mind struggles to process as time, he confessed to all 7 murders. He recanted almost immediately. He said he had confessed because of what was being done to him in that room, not because he had done what he was confessing to. His defense attorneys argued the confession was coerced. Evidence was examined and re-examined through years of legal proceedings. Eventually, after a process that itself lasted years, the man was acquitted. But here is what makes this case different from the others. Here is what makes it, in some ways, the most structurally disturbing entry on this list. In Japan, the statute of limitations on murder was, at that time, 15 years. By the time the acquittal came through, by the time the courts finished doing what courts do, working at the pace courts work, processing appeals and reviews and counter-appeals, the statute of limitations had expired on all 7 murders. 7 people were killed. The wrong man was jailed and subjected to violence to obtain a false confession. And when the justice system finally corrected its error, when it finally admitted it had imprisoned the wrong person, it also quietly closed the door on ever prosecuting the right one. Whoever killed those 7 people in Saga Prefecture between 1986 and 1988 cannot be charged. Not now, not ever. The law itself became a wall behind which they can stand, permanently. 7 families, 7 victims. 0 accountability, 0 possibility of justice, not as a failure of investigation, but as a mathematical certainty produced by the collision of a wrongful conviction and a ticking clock. Case 5. The Nagoya DNA exonerations. In 2009, when Toshikazu Sugaya walked out of Ashikaga prison, something cracked open in the Japanese public conversation about criminal justice. Not enough, but something. Amnesty International had been documenting Japan's interrogation practices for years before that moment, cataloging testimony from former detainees about conditions inside Daiokangoku. The substitute prisons, the police cells where suspects are held and questioned, separate from the formal prison system, with minimal external oversight. The UN Human Rights Committee had formally criticized the practice. Defense attorneys had been raising it in courts for decades. None of it had produced structural change. The Sugaya case made it harder, briefly, to look away. In the wake of that case, a small number of defense attorneys, legal scholars, and prosecutors began asking a question the system had not wanted to hear. How many other people are in prison right now, based on the same combination of inadequate forensic science and interrogation-derived confessions? The answer, when they started looking, was not reassuring. In the Nagoya region and surrounding prefectures, a systematic review of old convictions, cases where biological evidence existed but had never been subjected to modern DNA analysis, began returning results that matched the pattern investigators feared. Convictions that had appeared airtight, a confession, a motive, a credible but technically primitive forensic connection. One by one, these began to unravel under genetic testing that had not existed when the cases were originally tried. The pattern across every case was the same. A confession obtained during prolonged detention with no legal counsel present. Forensic evidence presented to courts as conclusive that was in fact the product of techniques now understood to be unreliable. A defendant who had been saying for years, or in some cases decades, that they did not do it, and whom no one had believed because the system had already decided, and the system did not like to revisit its decisions. The Nagoya cases did not produce a single dramatic, nationally covered exoneration. They produced something quieter and more troubling, a slowly growing list of names, people who had served partial or complete sentences for crimes the DNA evidence now indicated they had not committed. People who, in many cases, had already been released, who had done their time and moved on, in whatever fragmented way one moves on from a wrongful imprisonment, and who would never receive a formal accounting of what had been done to them. Case 6. The substitute prisoner phenomenon. There is a concept in Japanese criminal defense that does not translate cleanly into English. Practitioners call it the migawari, the substitute, the person who steps forward or is pressured forward to absorb responsibility for something done by someone else. It occurs in organized crime cases where a low-ranking member confesses to protect a superior. It occurs in family cases where a parent confesses to shield a child, or a spouse confesses to protect a partner. It occurs in workplace cases where an employee absorbs culpability for an employer or a colleague with more to lose. These are not hypothetical scenarios drawn from legal theory. They are documented in case files, in defense attorney testimony, in court records. But the Migawari phenomenon is not only produced by social loyalty or familial love, it is produced with reliable frequency by the architecture of the interrogation system itself. Consider what that system looks like from the inside. A suspect is held for 23 days. They are questioned for 12 hours a day. No lawyer is permitted in the room during questioning, a rule that has no equivalent in most democratic legal systems and that exists in the judgment of most human rights observers, specifically because its absence makes confessions easier to obtain. Outside the detention facility, the people the suspect loves are also being questioned, their routines disrupted, their lives placed under scrutiny. The investigators are not subtle about the connection between these two facts. The message, stated or implied, is consistent. If you confess, this ends. For you, for them. If you don't, this continues. For everyone. For a person formed within Japan's cultural tradition of collective responsibility, a tradition in which individual shame reflects on family, in which endurance and self-sacrifice carry genuine moral weight, the calculus of that situation is not what it would be elsewhere. Confessing to protect someone else is not irrational. In certain frameworks, it is logical. In certain frameworks, it is what you are supposed to do. The system provides no mechanism for distinguishing between these confessions and genuine ones. There is no protocol, no safeguard, no procedural check that asks, is this person confessing because they are guilty, or because they have decided that guilt is what the situation requires of them? Defense lawyers in Japan have documented clients who, after weeks inside that system, told them plainly, I know I didn't do it, but I also know that saying that hasn't worked, and I know what happens to the people I love if I keep saying it. The real perpetrators in these cases go free, protected by the very person the system was supposed to protect against them. Case 7. The Interrogation Reform Debate. In 2016, after years of advocacy from defense attorneys, human rights organizations, and legal scholars, Japan passed a package of reforms to its interrogation practices. The centerpiece was a requirement for video recording of interrogations. Rights advocates called it a beginning. They also called it insufficient, and they were careful to explain why. The recording requirement applied only to serious crimes. It did not apply to the full duration of interrogations. Recordings could cover select portions of the total questioning time, leaving substantial periods undocumented. Prosecutors retained significant discretion over which elements of the process were captured and which were not, and the reform addressed only the question of documentation. It did not address the underlying architecture. Lawyers are still excluded from interrogation rooms in Japan. The Daio Kangoku system, the substitute prison structure that allows suspects to be held in police cells under police supervision during the period when they are most actively being questioned, remains intact. The 23-day detention cycle, which can be applied sequentially across multiple charges to keep a suspect in custody for months without formal conviction, has not been changed. The career incentive structure that ties prosecutorial advancement to conviction rates has not been changed, and Japan's conviction rate, the number that opened this story, remains, to this day, above 99%. The conditions that produced Sugaya, Hakamada, and Mainali have not been structurally dismantled. They have been adjusted at the margins, in ways that satisfy a bureaucratic need to appear responsive without threatening the operational foundation of a system that functions, from the perspective of those who run it, extremely well. The machine is still running. It has new cameras in some of its rooms. The cameras watch parts of what happens. The rest remains unwatched, as it has always been. Case 8. The number that explains everything. 99%. In most functioning democracies, a criminal conviction rate of 70% would be considered acceptable, even healthy. Evidence that the system is testing its cases honestly and acquitting defendants when the evidence falls short. In the United States, federal conviction rates hover around 90%, and that figure draws consistent criticism from legal scholars who argue it reflects prosecutorial overreach rather than prosecutorial accuracy. In the United Kingdom, in France, in Germany, acquittals are treated as a normal and necessary feature of a functional adversarial legal system. They mean the process is working. They mean someone checked. In Japan, an acquittal means the prosecutor failed. Japanese prosecutors are career civil servants. Their advancement depends on their record. Their record depends overwhelmingly on their conviction rate. Because the system is built on this foundation, because the career consequence of losing a case is real and the career consequence of not bringing a case is minimal, prosecutors do not bring cases they are not certain they can win. The operative question is not, is this person guilty? It is, can I prove this person guilty? And in a system where a confession obtained through weeks of detention is treated as the highest and most persuasive form of evidence available, The institutional pressure to obtain that confession becomes not merely strong, but almost irresistible. Nyers, the judges who hear these cases, are also career civil servants, trained within and professionally loyal to the same institutional framework as the prosecutors they face. Jury trials in Japan are a relatively recent and structurally limited development. For most of the 20th century and well into the 21st, a single judge or a panel of judges decided guilt or innocence. Those judges were not neutral observers dropped into the process from the outside. They were products of the same system, educated in the same traditions, evaluated by the same institutional metrics. Acquitting a defendant that the prosecutor had deemed worthy of charge was, within that culture, a kind of institutional heresy. It was not impossible, but it required a kind of courage that systems of career advancement do not typically reward. When you understand this, when you understand the full weight of that architecture, the cases on this list stop being aberrations. They stop being stories about individual investigators who cut corners, or unlucky matches between weak evidence and vulnerable defendants, or failures of forensic technology that have since been corrected. They become what they actually are, the predictable output of a machine designed to convict, not to find the truth, not to pursue justice, to convict. The 99% is not a measurement of accuracy, it is a measurement of institutional will. Toshikazu Sugaya served 17 years for a murder he did not commit. Yuao Hakamada spent 46 years on death row and lost, in that time, some portion of his grip on the person he had been. A former boxer, a young man, a person with a life that the state erased while he waited for an execution that kept not coming. Govinda Prasad Mainali spent 15 years in a prison in a foreign country, in a language he did not fully speak, separated from his family, for a murder whose actual perpetrator's DNA sat in an evidence bag for years, waiting for someone to look at it properly. A man in Saga Prefecture was subjected to violence until he said the words the interrogators needed to hear, and then, when the system finally admitted what had been done, it discovered that the law had made justice permanently impossible. And somewhere, in all of these cases, there are real perpetrators, people who killed and walked away and watched, from whatever distance, as someone else absorbed the consequences. People who knew that a closed case was their protection. People who understood, perhaps without ever articulating it, that the best thing that could happen to them was for the police to stop looking, that the moment a confession was signed, the investigation ended, that the machine would take it from there. Those people are still out there, or they have died, free, having never been called to account for anything. The families of their victims received not justice, but its simulation, a trial, a verdict, a sentence, and the feeling of resolution, until the day the DNA results came back, or the court finally moved and the simulation collapsed. That is the other side of the 99% number. For every wrongful conviction, there is a case that was closed, an investigation that stopped, a murderer who became, in the eyes of the Japanese state, not a suspect but a background figure. And then, eventually, no one's problem at all. The machine moved on. It is still moving, and the number on the wall is still 99%. Japan's justice system is often praised for its 99% conviction rate. But behind that number are cases like these, people who lost years, decades, and sometimes entire lifetimes for crimes they never committed. And perhaps the most disturbing part is this: for every innocent person who was convicted, there was a real killer who wasn't. Some may still be alive today, some may have died free, but none were ever forced to answer for what they did. If this story made you think, leave a comment with your thoughts and subscribe for more true crime cases that history still hasn't fully explained.